Arrested for drunk driving and you weren't read your rights? Does it matter? 90% of the time, the answer is probably not. Let me explain why. The initial contact that you have with a police officer when they stop you for suspicion of drinking and driving, that's part of an investigation. You're not under arrest, and Miranda does not need to be given. However, answers that you give to that officer, those can still be used against you later. In drinking and driving cases, the majority of the evidence, maybe all of the evidence, that's going to be used against you is not going to be your statements. It's going to be the smell of alcohol on your breath, watery or bloodshot eyes, your ability to perform field sobriety tests, and the results of a blood, breath, or chemical test. Miranda keeps out your statements once you've been arrested and you weren't given a warning and you're interrogated. That evidence I just went over, none of those are statements. Rarely is Miranda going to help you in that situation. In the other 10% of cases where Miranda might help you, the scenario goes like this. The officer has contact with you. He suspects you were drinking and driving. He didn't actually see you drive. At that point, the officer is going to want to get you to admit that you drove recently. If the officer arrests you and gives you Miranda and you answer the question, it can be used against you. But if the officer doesn't read you Miranda and asks you the question, how did you get here? Were you driving? Anything like that, Miranda would keep that statement out. It's always just easier to decline to answer the officer's questions if you're being investigated for a crime. I hope you like this video. Don't forget to like, follow, and subscribe. I'm criminal defense attorney Aaron J. Boria. You can call me at 734-453-7806 or shoot me an email at borialaw@gmail.com. I'm happy to fight for you. Have a great day.